We turn to the next case on this morning's docket. That is case number 105678, State of Kansas v. Daniel Allen Brown.
May it please the Court, Rachel Pickering of the Appellate Defender Office on behalf of Daniel Brown. Chief Justice Nuss, if you could please reserve 2 minutes rebuttal time.
2 minutes is granted.
Thank you. There are several issues raised in Mr. Brown's brief, and I'd like to address Issue 2 only. Issue 2 is a quite interesting argument to be presented today because here we are dealing with the defendant's age once again. Back in March of 2009, this Court heard arguments in Bellow. 2 months later, I was up here arguing about the defendant's age in Gonzalez. This Court has held it to be an essential element of the crime. The beef that we have here, and I apologize for saying beef, I don't mean to belittle, is where does the defendant's age go when the jury is instructed? Now here, under Pick instructions, they took the verdict form and they separated it out from the jury instruction. And they placed the defendant's age, an essential element, outside the umbrella, the protection that is normally given to jury instructions. That's laid out in my brief of 2 things that are essential that were missed. So at trial, we do have an objection. The defense objected to the instructions. I quote that in my brief. The district court denied it, saying the jury can make a finding of the defendant's age in the verdict form. In fact, it's really not an essential element. It's really more of a finding.
Regarding the objection, how do we handle the situation where the record reflects that there was an objection, but then the trial court pointed out, but it's on the verdict form, and then defense counsel said, I didn't read that, that would eliminate that issue. Is that a withdrawal of the objection?
Could you say again what he said?
I didn't read that, that would eliminate that issue.
I don't know if that's I wouldn't know if that would be a complete withdrawal of the argument. I wouldn't say it's certainly not invited error there was an objection made.
But there wasn't an objection made on the basis of Osborne, the case that said that you don't use jury questions in criminal cases.
Right.
That objection was not made below.
Right. And I put that actually in my reply brief, where I said, we're actually making new arguments here, and I cite Pierce, which I don't have to, that we would look this under then at a clearly erroneous standard. I believe this court in a case, I believe it was Friday, actually Elmaker, when a trial objection and jury instruction is different from the argument presented in appeal, clearly erroneous standard applies. That's Elmaker. It's not cited in my brief, but I saw that in preparing for argument. Even under a clearly erroneous, we believe that there's a real possibility the jury could have rendered a different verdict. But before I jump to whether it's error or not, I want to just go through how, by placing the element alone, it loses protection. The jury is not told it's the state's burden. In fact, the state doesn't know it's its burden. The court doesn't know it's the state's burden. The court is told by Pick that the defendant should stipulate to his age. By not putting it with the jury instruction, any comments by the prosecutor, and here we have several, could be used to prove the element. That any comments by the prosecutor could be used to prove evidence should be disregarded. And here at closing, you have the prosecutor saying, "Look at him. You've been at this trial. You see how old he looks." Well, those comments and statements by the defense, by the state, Normally, under jury instructions, the jury would be instructed, instruction number 4, to disregard those, that those are not evidence. But here, when you take an element outside of the jury instructions protection, something that this court always says, you look collectively. You look at the state's burden, you look at the statement's argument.
I'm taking your argument to be that the separate verdict form or jury question form or whatever you want to call it is not part of the instruction package that we look at as a whole. Is that what you're saying?
Correct. Correct. It does say unanimous. It does say beyond a reasonable doubt. But nowhere is the jury told after it reaches that verdict that that question is still part of the jury instructions. In fact, proof of that is by the court and not knowing it's the state's burden. And the state not knowing it's its burden. And implication that the defendant should stipulate to this. Those factors in this case, I think, are a good example of how we can get tripped up by putting a central element into a special question. I believe it is error, and the impact is quite severe, as this court knows. The defendant's age is what puts it into an off-grid sentence. I argue that this is a constitutional error, that the jury was not convicted on the fact and law, and that with that, we take a look at what was presented. The state never asked the defendant about his age, didn't even know he had to present his proof. The state never asked the defendant's wife how old he is. Cross-examination, the state does not ask the defendant his age.
What's the impact? We have a motion for judgment of acquittal after the case, state's case in chief. We have a denial of that. But we don't have an issue raised on appeal that was an erroneous denial. So why would we be limited to looking at just the state's evidence?
You're not. You do, and because there was evidence presented, and I certainly consider that issue. There was evidence presented by the defendant, asked, how long have you lived in this area? 19 years. We would argue that that is indirect evidence. It's not substantial enough to reach beyond a reasonable doubt.
Even though we can prove elements and circumstantial evidence. We had the amount of time he'd lived there, and we also had the amount of time he'd worked at a certain place. Isn't that circumstantial evidence of his age?
Yes, I have thought of child labor, that because he worked at Goodyear for a few years, and I thought, well, maybe he, there's arguments there that he started, but yes, that was a
consideration. Can we look at the whole record like that, even though the state did not argue? The state didn't argue. The only argument to the jury that I can see is, hey, he looks old enough. And the only argument made to us was the defendant's statement that he'd lived for 19 years at that particular address. Even though the state hasn't argued that the other evidence, do we consider that? Do you understand, like the evidence of how long he's worked and the evidence that, like the trial judge said, well, they were drinking, so that infers they were drinking age and that kind of thing?
I would argue you can't do that, and that's actually in the next issue. That's regarding the insufficiency. That's the case I cited. I believe it's Perez, where you're looking at all the circumstantial evidence. Perez v. Rivera, where you're looking at all the circumstantial evidence of whether the victim was 18 years old. And there they say, well, she could drive and she could do all these things. And I would argue you really need to look at substantial, concrete evidence like you had in Renya. He's 37 years old. I don't think this court can start reaching into...
But that wasn't... My question was, can we look at the record on our own and pick out evidence to support, even though the state hasn't argued?
I don't think that that's the court's role to go through and start picking through the evidence, because the jury was given that opportunity already. in a sense. They just weren't told about the state's burden, and they weren't told that the prosecutor's statements should not be considered. And so for us to go in, the Supreme Court to go in and start going through the record, I don't think that's proper.
And you didn't raise an issue of prosecutorial misconduct with respect to the prosecutor's statement to the jury that their observation is proof beyond a reasonable doubt of the age.
I argued three things. I
understand, but I don't see where you raised that as an issue.
Correct.
So I have a question. When we get to cumulative error, I see that there are some things here that may potentially have been errors that were not preserved or not raised. And when we look at cumulative error, are we restricted to the errors that were properly raised and properly preserved? Or when we make a determination of fair trial, do we look at the totality of the circumstances? You understand what I'm saying?
Do you mean, can you sua sponte look at additional errors and looking at when you're doing your cumulative error analysis? Can you say, well, she raised prosecutorial misconduct, but she didn't talk about, just take a look at him, that I didn't raise that part. This court can sua sponte raise issues. I know that that's not always favorable, but you can in cumulative error. The cumulative error issue was presented. But this court has done that in other cases. State v. Adams, a speedy trial issue, you did so. But this court did. The Court of Appeals has done so in other cases. So that's how you can, and I'm sure this court has done in other cases. I just can't cite top.
So we would we would search the record, find error, and not be back with a brief from either the state or from you?
No, that's not how the rule works.
What are you saying?
The rule works is that, and this court said that in another case, the rule that from my understanding is that if this court should find something that I should have raised about the prosecutor saying, look at him, how old he is, and I didn't raise that as part of my prosecutorial misconduct, this court can order us to do supplemental briefing on it. And that's what it's done in the past.
But that wasn't my question. My question was, can that be part of the calculus of the cumulative error analysis that focuses on the fairness of the trial?
Oh, yes, okay, yes. The fairness of the trial is the key word here, because you're pointing out things that show that the trial was not fair, and I think this court can reach that, can look at those things. We would argue that Mr. Brown should have a reversal. We argue that there is cumulative error. I've listed several issues in my brief, and so I ask the support for reversal of convictions. If not, that, a remand for new trial. If not, resentencing under the grid offenses.
Any further questions of counsel? Thank you, counsel.
May it please the court, Gerald Kuckelman on behalf of the appellee, state of Kansas. The second issue that counsel is addressing concerning the jury instruction, I think the law requires that there be an instruction requiring the jury to make a finding of whether the defendant was over the age of 18 or not, and that was done in this case. The issue as to where it should have been placed, the district court followed the pick instruction on that, the suggestion in the comments to pick, they followed that, and we think that
How do you get around the fact that Osborne said that separate jury questions are improper in a criminal proceeding?
Well, I think the Osborne case was decided back in 1980, possibly, but it was a time before we had the Jessica's Law statute.
Well, I understand, but to get to allowing the pick procedure, we're going to have to overrule Osborne. It's never been overruled that I'm aware of, has it?
I could not find a case
And does
overruling
a pick committee's notes overrule a Supreme Court case?
They certainly do not.
Okay.
And-
So basically, how do we get around the fact that that was contrary to existing case law to do it that way?
Well, I think that this court could overrule Osborne and say that it doesn't apply in this particular situation. In this case, Jessica's law is a little bit different because it's an element of the crime, but it's not that way in the statute. It's into the sentencing part of the laws as opposed to the elements that define the crime. And inserting that element into the instruction that gives the other elements, if it was put in there the way the appellant proposes, it requires that finding, but it would make a finding of not guilty if that element wasn't proven, which is not really what Jessica's law is about. It's about sentencing. And so perhaps the way it was done is the way it ought to be.
Are we still talking about this as a sentence enhancement factor? Because I thought the federal Supreme Court made it pretty clear that we don't care where you put it. Whether you put it in sentencing statute or whatever, it's a functional equivalent of an element.
And I believe that's clear, that it is an element of the crime.
And isn't it also contained within the statute that defines the crime, that says it's off-grid if the defendant's over age 18?
It is in the penalty section
And
of
so
it.
if it's in the statute that defines the crime, why isn't it an element that should be charged with the other elements?
Well, I think it could be put in as part of the other elements. If they also added an alternative, if the state didn't prove the age, then it would be the lesser crime.
And there's been some courts that have talked about the problem of serial findings. You find this, and then if you find this, and then you find this, and then you find that it dilutes the jury's function to either find guilt or not guilty. How would you address that problem wouldn't be here in this case, when actually the jury here had to find, okay, we find guilt, and then we find that he's 18.
Well, the other way of doing it is to find that he's guilty of the off-grid felony or he's guilty of the other. When either way you do it, you've got two questions for the jury, because the grid sentencing is going to be a lesser offense of the off-grid.
Well, you do it the same way you do any lesser included offense, like the value of the property is $1,000 or not. You charge the elements of the crime that you're prosecuting, which in this case was the off-grid version, and then you can include a lesser included if you want to. But the point is that the jury looks at all of the elements at the same time and makes a determination of guilt or innocence. It doesn't make serial decisions one after the other.
Well, I would agree that may be the better way to do it, is to do it the same way you do the theft statute or the criminal damage or whatever. But that wasn't what was done here, and I think the question is whether it was an error to do it the way it was done here.
What about the burden of proof? Your opponent's point that not having this element as part of the elements instruction removes some protections that are built into the instructions, like the burden of proof being allocated to the state, the burden being beyond a reasonable doubt. What about that point? What's your response?
Well, I think that the question, the way it was worded, asked, was it proven beyond a reasonable doubt?
Okay.
And so I think you're asking the jury the same thing, it's just in a different location in the instructions.
But what you're asking the jury isn't really her question, I don't think. The way I understood, if it's separate, the jury has been instructed that your comments in closing aren't evidence, right?
Correct.
If this second question is outside of that instruction package, and that doesn't apply, then they can go along with what you said, and you said, just look at him, he's 18, and that's sufficient, and they could use your statement to make that finding because they weren't constrained by the instruction package. That was her argument, and I think Justice Breyer wants you to say, how do you respond to that?
Well, I think the instructions say that the state has to prove every element beyond a reasonable doubt. And
They do. There's all kinds of protection in the instructions, but the instruction leads you to a determination of guilt or innocence. It doesn't ordinarily lead you to making special findings after you've already made that determination.
Well, I think the instructions also say that you should consider the instructions as a whole, and that none of them should be singled out. You should read them as a whole, and I think that tells them how to do it.
Problem is, it's not under the instructions. I'm going to take one more run at this. I think what we're trying to get you to focus on is your opponent's argument that you have, excuse me, I have a little cold, you have the instructions universe over here, and then you have a special question. And so the things that you're citing to support that there's no error are over here in the instructions universe. And this is over here by itself. What your opponent argued is that in the instructions universe, there are protections. There are protections like who has the burden of proof, for example. That was the one I used. My colleague used a different one. But the point is, there are protections in this universe. And then you just have this question over here with a lot less of those protections, or a lot fewer of those protections. That's your opponent's argument, and we wanted to know your response to that.
Well, I understand where you're at, but
Okay.
but the instructions saying consider them as a whole.
But
to consider
this is
everything.
outside the instructions. Consider the instructions as a whole. That's in the instructions universe. We're talking about this question that's out here orbiting somewhere else.
Well, and for example, in application, you cite the instruction that says that the state must prove the elements beyond a reasonable doubt. What instructs the jury that age is an element?
I guess the answer is nothing instructs the jury that it's an element, but the jury is asked, do you find this beyond a reasonable doubt? I think that's the only protection.
But they don't have the state's that it's the state's burden to prove it. Whether or not that's significant, I guess, is part of the harmless inquiry, but they don't have that in the instructions.
It's not there with the other elements. I don't know what else I can say. It's not there, but does that really mislead the jury, I think, is the better question. I mean, they're still told you got to find this beyond a reasonable doubt. And apparently they did, because they marked yes. And I know where we're headed next, and I was wrong. I don't know what else I can say. At the time of this trial, I was not fully prepared, apparently, because I was not understanding that what we needed to do to prove the defendant's age. And I said, look at him, you can tell he's over 18. I can't undo that. I wish I could. I've thought about it a lot through the course of this, and I wish I could. But nonetheless, there was evidence of his age. There was evidence that they could rely on. And all I can say about my wrong comment was that the court instructed them that the comments of counsel are just comments and not to be considered as evidence. There was evidence of his age. He said he lived in a particular place for 19 years. I think that that's enough to show that he's over the age of 18. So
even if that was error, that it was harmless. That's your argument.
it is. It is.
Okay.
Well, one point, though, that I think Justice Lukert raised at the very beginning of the appellant's argument was about the objection to the special question. And, I think if you read that transcript, I think defense counsel says, where's the question? The judge points it out, and I think he basically says, okay. I don't know that he uses that term, but the defense was not objecting to the way it was done. They seem to be concurring with it.
He said, okay, that would eliminate that issue.
Yes.
The court says, all right, do you have any other objections? And he says, no. So is it your position that he's withdrawn his objection, or that's insufficient to be an objection, or it's ambiguous?
I think he basically acquiesced to the way the question was being presented when he said, okay.
Do you have a response to the question I posed to opposing counsel with regard to the scope of our review on the cumulative error? And specifically, let me get more specific, that I don't see that the fact that you made the admittedly wrong statement in closing argument was raised as an issue. They complained about 3 different things that was in closing, but I don't see a specific issue raised with regard to that. But you've admitted that misdirected the jury with what evidence they could use. And my question is, can that be part of our calculus when we look at the cumulative error, even though it wasn't a raised issue in this case? Do you understand where I'm trying to get to?
I do, Justice, and you know, I think ultimately it's this court's responsibility to make sure a defendant gets a fair trial. I think that that's your duty, and whether counsel points it out or not, I think that this court has to consider the totality of whether he got a fair trial. And if he didn't, then he didn't. I hate to argue against myself, but
We like candor in this courtroom. Any other presentation, counsel?
nothing else.
Okay, any further questions of counsel? Thank you.
To get back to the cumulative error, I have great respect for you for talking about the defendant's right to a fair trial, because that's what we're all about. People ask me, what do you do at your job? I'm here as a watchdog to make sure the defendant gets a fair trial. And I didn't raise that other statement in the prosecutorial misconduct. But at oral argument, you do have a statement by the state acknowledging that that was a mistake. This court has said several opinions, at argument this was conceded. And so here we have the state conceding a point. And so I think that statement did misdirect the jury.
Well, the judge used the same erroneous tact on denying the motion for judgment.
Right.
It said other things.
Right.
But you didn't challenge that either. I mean, we can't find error based on the denial of the motion for judgment of acquittal if you haven't raised that as an issue, can
Right, but I've raised so many other issues. Prosecutorial misconduct. Let's take a look at what was. I have 48 seconds of rebuttal, but there was insufficient evidence here. You do have an improper jury instruction. You do have misconduct about suggesting that the defendant has incestuous desires for his 11-year-old stepdaughter. That is quite inflammatory. You have misstatements about what the nurse says. And there's a third one. I think you have enough here.
Treated his wife like a slave.
What?
Treated his wife like a slave.
Thank you.
Yeah.
Thank you. Treated his wife like a slave. I think those 3 things, incestuous desires for a stepdaughter, treats his wife like a slave, misstatement of the fact about the nurse. I think those enough, along with the others issue, is enough for cumulative error. And I ask this court for a reversal on Mr. Brown's convictions.
Any further questions of counsel? Before you sit down, I'd like a clarification. Your opinion on what our standard of review on this special question is what?
Yes.
What is it?
I was going through that in my notes. After Justice Lukert's statement, it's going to have to be clearly erroneous. I started off with a de novo standard review in my brief, but this is a jury question problem, and so it would probably be a clearly erroneous standard.
All right, thank you. Any further questions? Thank you both for your arguments this morning. Court will take this matter under advisement.